23rd November, 1971, Westfield, New Jersey. A county clerk stamps a missing persons report at 2:17 in the afternoon. The house on Hillside Avenue stands empty, lights burning in every window, classical music playing on repeat. Neighbors noticed nothing unusual for 19 days. The file that follows, 5 victims, single offender, methodical planning, will become a template for understanding family annihilation in American criminology. Statutes promised uniform punishment for such losses. The record shows 7 cases, 5 states, outcomes ranging from execution to insanity, acquittal to life with parole. Identical tragedies, wildly different legal endings. One defendant waived all appeals and died by execution within 3 years. Another has filed federal habeas petitions for 5 decades. A third received a verdict of not guilty by reason of insanity after retrial. This is a story about what happens when an entire household is lost, and how statutes, mental health findings, and state borders determine whether justice means death, decades, or treatment. FBI Behavioral Analysis Unit Classification Memo, 2005, establishes the 3-type family killer taxonomy used in contemporary investigations. The Federal Bureau of Investigation's Behavioral Analysis Unit does not use family annihilation as a legal term. Courts charge individual homicides. Prosecutors prove each death separately. But criminologists recognize a pattern: the destruction of an entire household by a family member. 3 categories emerge from the data. Self-righteous killers believe they are saving their families from shame or hardship. Disappointed killers respond to perceived rejection or abandonment. Paranoid killers act on delusions or severe mental illness. The classification helps investigators understand motive. It does not determine legal outcome. That depends on charge, jurisdiction, and mitigation. The 7 cases in this account span all 3 categories. Each produced a different result. The framework exists to organize understanding. The law exists to assign responsibility. Sometimes the two align. Often they diverge. 5 of these 7 cases resulted in convictions in custody. 1 ended in execution by the offender's own request. 1 produced an insanity verdict after a successful appeal. All 7 involved the loss of multiple family members. None followed the same legal path. The contrasts begin with definitions and continue through every stage of prosecution, sentencing, and review. Family annihilation differs from serial homicide. Serial killers target strangers or acquaintances over time. Family annihilators destroy their households in a single event or compressed time frame. The FBI memo distinguishes carefully. Serial cases require pattern evidence, behavioral linkage, and often forensic corroboration across separate incidents. Family cases cluster in one location, one relationship network, one burst of violence. The legal strategies differ accordingly. Prosecutors in family cases emphasize premeditation and the vulnerability of victims. Defense attorneys focus on mental state, impairment, and the absence of prior violence. Juries hear testimony about the family's private life. The public watches, and statutes promise certainty. The docket tells another story. Each case begins with a discovery. A neighbor calls police, a relative arrives to find silence, a coworker notices an absence. The initial report triggers investigation, arrest, and charge. Then, the legal machinery engages: bond hearings, grand juries, motions, trial, sentencing, appeals. Some cases move quickly, others stretch across decades. Geography matters. A killing in Arkansas in 1987 proceeded to execution in 3 years. A killing in North Carolina in 1970 generated federal appeals for 50 years. Same crime, different century, different state, different result. Union County Superior Court docket, State Ver. List, 1990, shows charge structure and 18-year fugitive period. John Emil. List disappeared on 9th November, 1971. Police entered his Westfield home on 7th December. They found 5 bodies: Helen List, age 46, Alma List, age 84, Patricia List, age 16, John Frederick List, age 15, Frederick Michael List, age 13. All had been shot. The husband and father had vanished. Investigators learned he withdrew money, closed accounts, and mailed a letter to his pastor explaining his actions. He believed his family faced financial ruin and spiritual danger. He thought death was mercy. Then he started a new life under a false name. 18 years passed. A television program featured the case in May 1989. A tip led to Virginia. Robert Peter Clark, an accountant in Richmond, matched the age-progressed sketch. Fingerprints confirmed his identity. John List was arrested 11th June 1989. Extradition brought him back to New Jersey. The trial began in February 1990. Prosecutors presented the methodical nature of the planning. The letter, the financial transactions, the cleanup, the music left playing. Defense attorneys argued severe depression and religious delusion. The jury convicted on all 5 counts of first-degree murder. Judge William Lestrange sentenced List to 5 consecutive life terms. New Jersey had abolished the death penalty in 1972, shortly after List fled. List filed appeals. The New Jersey Supreme Court affirmed the conviction in 1992. Federal habeas petitions followed. All were denied. List remained in custody at the New Jersey State Prison in Trenton. He gave interviews. He expressed no remorse. He maintained he had acted to save his children's souls. Prosecutors and victims' advocates noted the contrast. A man who killed his family and hid for nearly 2 decades then claimed moral justification. The law offered no mitigation for religious motive. The sentence stood. List died in prison 21st March 2008 at age 82. He served 18 years for 18 years of freedom. The symmetry was noted in press coverage but held no legal significance. The List case became the template for understanding family annihilation in the United States. It combined financial pressure, religious delusion, and methodical planning. It demonstrated how a fugitive could vanish before digital tracking, and it showed that a state without a death penalty could still impose effective finality through consecutive life terms. The case also raised a question that would echo through the other 6. If mental illness or delusion drives the crime, should the punishment change? New Jersey law said no. Other states would answer differently. South Carolina jury verdict form, 1995, records life sentence despite prosecutor's capital recommendation. Susan Lee Vaughn Smith drove her Mazda into John D. Long Lake on 25 October 1994. Her sons, Michael Daniel Smith, age 3, and Alexander Tyler Smith, age 14 months, drowned strapped in their car seats. Smith told police a black man had carjacked her vehicle with the children inside. The story unraveled within days. She confessed 9th November. She admitted releasing the parking brake and watching the car roll into the water. She said she felt overwhelmed and wanted to be with a man who did not want children. The prosecution charged Smith with 2 counts of murder. South Carolina law allowed the death penalty. Solicitor Thomas Pope announced he would seek it. The trial began in July 1995. Prosecutors emphasized premeditation and the helplessness of the victims. The defense presented psychiatric testimony. Dr. Seymour Halleck, a forensic psychiatrist, described Smith's history of depression, suicide attempts, and childhood sexual abuse. He testified she was impaired but not legally insane. The jury convicted on both counts 22nd July. The sentencing phase began. South Carolina law required the jury to weigh aggravating and mitigating factors. Aggravation, 2 victims, both children, both defenseless. Mitigation, mental illness, trauma history, lack of prior violence, age. Smith was 23. The defense called family members who pleaded for her life. The prosecution showed videotape of the boys. The jury deliberated. On 28th July, they returned a verdict: life in prison. South Carolina law at the time required a 30-year minimum before parole eligibility. Smith would be 53 at her first hearing. The verdict surprised many. Polls showed public support for execution. Prosecutors had argued forcefully, but the jury saw sufficient mitigation. One juror later said the psychiatric evidence mattered. Another mentioned Smith's youth. The law gave them discretion. They used it. Smith's life sentence stood on appeal. She remains in custody at the Leith Correctional Institution in Greenwood County. Her first parole hearing occurred in November 2024. The board denied release. She will be eligible again in 2 years. The Smith case demonstrated that even in a death penalty state, mitigation can prevail. Her mental health history, her age, and the absence of prior violence created doubt about the appropriateness of execution. The jury imposed a severe sentence, life with a 3-decade minimum, but stopped short of death. That distinction matters. It separates Smith from Ronald Gene Simmons, whose case proceeded to execution, and aligns her more closely with Chris Watts, who accepted life without parole. Same crime category, different outcomes. The pattern continues. Arkansas Supreme Court Order, 1989, documents Simmons's competency hearing and verified appeal waiver leading to execution. Ronald Gene Simmons killed 16 people over a week in December 1987. 14 were family members. 2 were strangers shot days later. The killings occurred in Russellville, Arkansas. Simmons methodically shot and strangled his children, grandchildren, and wife. He waited for each arrival. He disposed of bodies in a cesspool and the home. After completing the family killings, he drove to Russellville and shot a woman who had spurned him and a man who worked at a convenience store. Police arrested him 28th December. Arkansas charged Simmons with capital murder. The trial proceeded quickly. He pleaded not guilty but offered no real defense. The jury convicted on all counts in May 1988. The same jury sentenced him to death. Arkansas law allowed execution for multiple homicides. Simmons qualified by an order of magnitude. The death sentence was entered. Appeals were automatic. Simmons filed a notice. Then he did something unusual. He asked the court to stop his appeals. He said he wanted to die. Arkansas law allowed a defendant to waive appeals if competent. The court ordered a psychiatric evaluation. Dr. Raj Sharma examined Simmons in October 1988. He found no evidence of psychosis or impaired judgment. Simmons understood his situation. He knew execution was the consequence. He preferred death to decades in custody. The Arkansas Supreme Court held a hearing. Prosecutors and defense counsel argued. The court reviewed the competency report. On 9 February 1989, the court issued its order. Simmons was competent. He could waive appeals. The execution was scheduled. Legal scholars and advocates objected. They argued the state should not facilitate suicide. They noted Simmons showed signs of depression. The court found depression alone did not equal incompetence. Simmons met the legal standard. Federal courts declined to intervene. Simmons's execution proceeded 31st May 1990. He died by lethal injection at the Cummins unit in Grady. He was 49 years old, the time between crime and execution, 2 years, 5 months. The Simmons case remains the fastest resolution in this group. It also stands as one of the largest intra-family killings in U.S. history. 16 victims, 14 family members spanning 3 generations. The competency to waive appeals question created precedent in Arkansas. Courts in other states cited the Sharma evaluation framework. Simmons's decision to embrace execution rather than fight it underscored a grim reality. Some offenders see death as preferable to life in maximum custody. The law accommodated that choice. Victims' families gave mixed statements. Some wanted him to suffer longer, others wanted closure. The execution provided finality. But it also foreclosed decades of potential legal development. Simmons's case never tested evolving mental health defenses. It simply ended. Weld County Plea Agreement, 2018, shows LWOP deal accepted to avoid trial and Colorado's later death penalty repeal. Christopher Lee Watts killed his wife and 2 daughters 13th August 2018 at their home in Frederick, Colorado. Shanann Watts, age 34, was 15 weeks pregnant. Bella Watts, age 4, and Celeste Watts, age 3, were smothered. Watts disposed of all 3 bodies at an oil site where he worked. He reported them missing. Television crews covered the search. Watts appeared on camera pleading for their return. Police suspected him immediately. Polygraph results showed deception. Watts confessed 15th August. The Weld County District Attorney's Office charged Watts with 3 counts of first-degree murder after deliberation, 2 counts of murdering a child under 12, 1 count of unlawful termination of a pregnancy, and 3 counts of tampering with a deceased body. Colorado retained the death penalty in 2018. Prosecutors announced they would seek it. Shanann Watts' family made a decision. They asked prosecutors to offer a plea deal. They did not want a trial. They did not want to hear details. They wanted certainty. The state agreed. On 6 November 2018, Watts appeared in court. He pleaded guilty to all counts. Judge Marcelo Kopkow accepted the plea. The sentencing hearing occurred 19th November. Shanann's father, Frank Razuchek, gave a victim impact statement. He said the family wanted Watts in prison forever, but did not want the stress of a capital trial. The judge imposed 3 consecutive life sentences without the possibility of parole, plus additional years for the other counts. Watts was transported to the Dodge Correctional Institution in Wisconsin under interstate compact due to safety concerns. He later returned to Colorado custody. In March 2020, the Colorado legislature repealed the death penalty. Governor Jared Polis signed the bill and commuted the sentences of the 3 men then on death row to life without parole. Watts was already serving LWOP, so the change did not affect him. But the EDT timing underscored a shift. Had Watts rejected the plea deal and proceeded to trial in 2019 and had a jury sentenced him to death, that sentence would have been commuted 14 months later. Instead, the plea locked in LWOP immediately. The outcome was identical. The path was different. The Watts case became a media phenomenon. A Netflix documentary examined the investigation. True crime podcasts analyzed the case for months. Watts gave a prison interview in 2019, offering explanations that contradicted his confession. Legal experts noted the case as an example of victim-family agency. The Razucheks chose speed and certainty over a lengthy capital trial. Colorado law allowed that choice. The plea achieved finality faster than any contested case could. Watts will die in custody. The law guarantees it. The family asked for it. The court granted it. 3 sentences, no parole, no end. New York Department of Corrections status sheet, 2021, final custody record before death, showing continuous incarceration since 1974. Ronald Joseph DeFeo Jr. shot 6 family members 13th November 1974 in Amityville, New York. The victims: Ronald DeFeo Sr., age 43, Louise DeFeo, age 42, Dawn DeFeo, age 18, Allison DeFeo, age 13, Mark DeFeo, age 12, John Matthew DeFeo, age 9. All were shot with a .35 caliber rifle while they slept. DeFeo called police hours later, claiming he found the bodies. Investigators quickly identified inconsistencies. He confessed within 24 hours. He said voices commanded him. He later recanted and offered multiple explanations. The trial began in October 1975. The defense argued insanity. Dr. Daniel Schwartz, a defense psychiatrist, testified DeFeo suffered from a mental disorder. Prosecution experts disagreed. Dr. Harold Zolan testified DeFeo had antisocial personality disorder, but was not legally insane. The jury deliberated. On 21 November 1975, they convicted DeFeo on 6 counts of second-degree murder. New York law imposed 25 years to life on each count. Judge Thomas Stark ordered the sentences to run consecutively, 150 years minimum. DeFeo appealed. The appellate division affirmed. The New York Court of Appeals declined review. Federal habeas petitions were denied. DeFeo remained in custody at Green Haven Correctional Facility, later transferred to Sullivan Correctional Facility. He filed parole applications. All were denied. The board cited the severity of the crimes and DeFeo's continued refusal to accept full responsibility. Over decades, DeFeo gave interviews. He changed his story repeatedly. He blamed a mob hit. He blamed his sister. He claimed self-defense. Legal experts noted the inconsistency damaged his credibility. The Amityville case became famous not for its legal proceedings, but for a subsequent hoax. The Lutz family purchased the EDP house in December 1975. They claimed paranormal events drove them out. A book and film franchise followed. The Amityville Horror became a cultural phenomenon. DeFeo's actual case was buried under fiction. Prosecutors and victims' advocates repeatedly clarified the murders were real, documented, and judicially resolved. The ghosts were invented. The conflation frustrated families and legal professionals. The murders deserved sober acknowledgement. Instead, pop culture turned tragedy into entertainment. DeFeo died in custody 12 March 2021 at age 69. He served 46 years. His New York Department of Corrections status sheet recorded continuous incarceration from 1974 to 2021. No parole, no release, no change in conviction. The legal outcome was final in 1975. The cultural noise continued for decades. The case demonstrates how a straightforward criminal proceeding can be overshadowed by myth. DeFeo killed 6 family members. A jury convicted him. The state imprisoned him for life. Those facts should be sufficient. The ghost stories are not part of the legal record. They never were. Fourth Circuit Court of Appeals decision, 2017, denies final DNA testing motion after 47 years of appeals. Jeffrey Robert McDonald was convicted of murdering his wife and 2 daughters, 17 February 1970, at Fort Bragg, North Carolina. Colette McDonald, age 26, was pregnant. Kimberly McDonald, age 5, and Kristen McDonald, age 2, were stabbed and bludgeoned. McDonald, an Army captain and physician, told military investigators intruders broke in and attacked the family. He described 4 assailants, including a woman in a floppy hat. The crime scene suggested otherwise. Blood patterns, fiber evidence, and the lack of significant injury to MacDonald raised suspicions. The Army charged MacDonald with the murders. An Article 32 hearing in 1970 resulted in dismissal of charges. The case was closed. Colette's stepfather, Freddie Kassab, pressed for reinvestigation. The Justice Department reopened the case in 1971. A grand jury indicted MacDonald in 1975. The trial occurred in 1979 in Raleigh. Prosecutors presented forensic evidence: pajama top fibers found under Colette's body, blood type patterns inconsistent with MacDonald's story, and the physical layout of the scene. The defense argued the military investigation was flawed and evidence was contaminated. The jury convicted on 3 counts. Judge Franklin Dupree sentenced MacDonald to 3 consecutive life terms. MacDonald appealed immediately. The Fourth Circuit reversed in 1980, citing delays between indictment and trial. The Supreme Court reinstated the conviction in 1982. MacDonald entered custody at the Federal Correctional Institution in Terminal Island, California. He later transferred to Sheridan, then to Cumberland, Maryland. The appeals continued. MacDonald filed habeas petitions in 1984, 1990, 2003, and 2006. Each alleged prosecutorial misconduct, newly discovered evidence, or Brady violations. Each was denied. In 2012, MacDonald's attorneys filed a motion for DNA testing. They argued new technology could test hair and fiber evidence more precisely. The district court denied the motion. The Fourth Circuit affirmed in 2014. MacDonald appealed again. In August 2017, the Fourth Circuit issued a final ruling. The court found no reversible error. The DNA evidence would not change the outcome. The conviction stood. MacDonald remains in custody at the Federal Correctional Institution in Cumberland. He is 92 years old as of 2024. He has filed statements maintaining innocence. His appeals have failed. Parole eligibility exists under older federal law, but the U.S. Parole Commission has repeatedly denied release. The MacDonald case holds the record for the longest appellate litigation in this group. 54 years from crime to the latest docket entry, the case demonstrated how federal habeas proceedings can stretch across decades. It also showed the limits of new forensic testing. Courts require petitioners to prove that results would have changed the verdict. MacDonald's attorneys could not meet that threshold. The conviction, entered in 1979, remains in effect. The appeals have stopped. The custody continues. Finality arrived not through execution or commutation, but through exhaustion of legal avenues. The docket is silent now. The sentence is not. Texas Court of Criminal Appeals Reversal Order, 2005, overturns conviction due to false expert testimony. Retrial results in not guilty verdict. Andrea Pia Yates drowned her 5 children 20th June 2001 in the bathtub of the family's Houston home. Noah Yates, age 7, John Yates, age 5, Paul Yates, age 3, Luke Yates, age 2, and Mary Yates, age 6 months, all died by drowning. Yates called police and her husband immediately after. She told officers she killed her children. She said she was a bad mother. She said Satan was inside her. She appeared calm and detached. The Harris County District Attorney's Office charged Yates with capital murder. Texas law allowed the death penalty. Prosecutors announced they would seek it. The trial began in February 2002. The defense argued insanity. Yates had a documented history of postpartum psychosis. She had attempted suicide twice. She had been hospitalized multiple times. Psychiatrists testified she suffered from severe delusions. Dr. Philip Resnick, a forensic psychiatrist, explained that Yates believed killing her children would save them from eternal damnation. She thought she was protecting them. Prosecutors countered with Dr. Park Dietz, who testified about an episode of the television show Law and Order Special Victims Unit that featured a woman drowning children and using an insanity defense. Dietz said the episode aired before Yates' crime. The jury convicted Yates on 12 March 2002. The sentencing phase began. Prosecutors sought death. The jury imposed life in prison instead. Yates was sentenced to 40 years with possibility of parole. The verdict shocked advocates. The evidence of mental illness was overwhelming. But the conviction stood. Yates was transferred to the Mountain View unit in Gatesville. Then, the case unraveled. Defense attorneys discovered that the Law and Order episode Dietz described did not exist. No such episode aired before the crime. Dietz acknowledged the error. The defense filed a motion for new trial. The trial court denied it. The defense appealed. The Texas Court of Criminal Appeals reviewed the claim. On 6 January 2005, the court issued its order. The false testimony was material. It could have affected the jury's verdict. The conviction was reversed. The court ordered a new trial. The retrial began in June 2006. Prosecutors again sought a conviction, but not the death penalty. The defense presented the same psychiatric evidence without the false testimony to rebut. Dr. Resnick returned. He explained postpartum psychosis in detail. He testified that Yates met the legal standard for insanity under Texas law. The jury deliberated. On 26 July 2006, they returned a verdict, not guilty by reason of insanity. Yates was committed to the North Texas State Hospital in Vernon, a maximum security psychiatric facility. She remains there. Under Texas law, she can petition for release only if a court finds she is no longer dangerous. No such finding has been made. The Yates case stands as the only insanity acquittal in this group. It also represents one of the clearest examples of appellate reversal due to prosecutorial error. The false testimony about the television episode was small in the context of the entire trial, but the Texas Court of Criminal Appeals found it material enough to require reversal. The retrial jury, hearing the psychiatric evidence without the false rebuttal, reached a different conclusion. Yates was mentally ill, not criminally responsible. The outcome reflects Texas's recognition of severe mental illness as a complete defense. She was not sentenced, she was committed. The distinction is critical. It separates her from every other case in this account. Comparison chart of mitigation outcomes across all 7 cases shows documented psychiatric findings and resulting verdicts. Andrea Yates succeeded where others failed. The question is why? All 7 cases involved family annihilation. Several involved documented mental illness, but only Yates received an insanity verdict. The answer lies in the quality of psychiatric evidence, the timing of evaluation, the strength of documentation, and the willingness of juries to apply the insanity standard. Yates had been hospitalized multiple times before the crime. Her medical records were extensive. Her psychiatrists had diagnosed postpartum psychosis and prescribed antipsychotic medication. She had discontinued the medication days before the drownings. Her delusions were documented in hospital notes, not reconstructed after arrest. Other defendants claimed mental illness. Ronald DeFeo said voices commanded him. John List said religious delusion drove him. Susan Smith described depression and trauma. But documentation varied. DeFeo's psychiatric evaluations found personality disorder, not psychosis. List's religious beliefs were coherent, not delusional in the clinical sense. Smith's depression was real, but did not meet Texas's high bar for insanity. She knew her actions were wrong. Yates, by contrast, believed she was saving her children. Her delusion was religiously framed but psychiatrically rooted. She met the legal test. The insanity defense succeeds in fewer than 1% of felony cases nationally. It requires proof that the defendant could not understand the nature of the act or distinguish right from wrong at the time of the offense. Yates's delusion fit that framework. She believed she was acting morally by preventing her children's damnation. The jury in her retrial accepted that explanation. Other juries did not find similar evidence in the remaining cases. The Smith jury saw mitigation sufficient to avoid death, but not to acquit. The DeFeo jury rejected insanity entirely. The difference was not sympathy, it was evidence. Texas law sets a high standard. The defendant must prove insanity by a preponderance of the evidence. Yates's attorneys met that burden with hospital records, prescriptions, contemporaneous psychiatric notes, and expert testimony from respected forensists. The retrial jury reviewed all of it without the distraction of false rebuttal testimony. They concluded Yates was insane. That verdict did not free her. It redirected her to civil commitment. She remains in maximum security psychiatric custody. Release requires proof she is no longer dangerous. No court has found that. But her legal status differs fundamentally from the others. She was found not guilty. The verdict acknowledged her mental state. The law provided an outcome other than prison. That outcome is rare. The Yates case shows it is possible. State-by-state capital sentencing data, 1970-2020, demonstrates execution rates and LWOP adoption timelines. Geography shaped every outcome. John List committed murder in New Jersey in 1971. New Jersey had abolished the death penalty the year after. List faced life terms. Ronald Gene Simmons killed in Arkansas in 1987. Arkansas retained capital punishment. Simmons was executed. Chris Watts killed in Colorado in 2018. Colorado still had the death penalty but repealed it. 18 months later, Watts received life without parole by plea. Andrea Yates killed in Texas in 2001. Texas leads the nation in executions. Yates was committed to a psychiatric hospital. The crimes were similar. The states were not. Capital sentencing data from 1970 to 2020 show striking disparities. Texas executed 573 people in that period. New Jersey executed 0. Arkansas executed 31. Colorado executed 1 in 1997. New York, where DeFeo was convicted, abolished the death penalty in 2007, but had not executed anyone since 1963. Federal cases like McDonald's proceed under separate rules. The federal system executed 3 people between 1976 and 2020. McDonald was never sentenced to death. He received life terms under the sentencing regime in place in 1979. Life without parole emerged as an alternative to capital punishment. States adopted LWOP at different times. Some used it to replace the death penalty. Others used it alongside capital sentencing. The result: defendants convicted of nearly identical crimes faced different maximum sentences based solely on where the crime occurred. Simmons in Arkansas was executed. Watts in Colorado received LWOP. List in New Jersey received multiple life terms with the possibility of parole under old law, though he was never released. Smith in South Carolina received life with a 30-year minimum. The pattern is inconsistent because states write their own sentencing statutes. Federal appellate data shows similar disparities in reversal rates. State courts reversed convictions in capital cases at higher rates than in non-capital cases due to the heightened scrutiny required. Yates's reversal fit that pattern. DeFeo's conviction stood despite numerous appeals because New York's appellate courts found no reversible error. McDonald's federal appeals stretched for decades, but the Fourth Circuit consistently affirmed. The Simmons case bypassed much appellate review because Simmons waived his rights. The length, complexity, and outcome of appeals depend on the defendant's choices, the strength of trial evidence, and the appellate court standards. No two paths match. The data reveal another truth. Public expectation does not align with legal reality. Surveys show most people believe family annihilators face execution or life without parole. The record shows otherwise. 1 execution, 1 insanity acquittal, 3 LWOP sentences, 1 life with parole eligibility, 1 death in custody after decades. 7 cases, 7 outcomes, no uniform pattern. The law is not a monolith. It is 51 systems, 50 states plus federal, each with different statutes, different procedures, and different priorities. Geography is not just context, it is determinant. American Bar Association Competency to Waive Appeals Guidelines, 1988, Framework. Used to evaluate Simmons's decision, Ronald Gene Simmons wanted to die. He said so clearly. Arkansas law allowed him to waive appeals if he was competent. The question was whether his choice was knowing and voluntary. The American Bar Association issued guidelines in 1988 addressing competency to waive. The framework required 3 findings. The defendant understands the charges and potential punishment, the defendant understands the effect of waiving appeals, and the defendant's decision is not the product of coercion or mental illness that impairs judgment. Arkansas courts applied that framework to Simmons. Dr. Raj Sharma's evaluation found Simmons understood his situation. He knew he had been sentenced to death. He knew appeals could delay or potentially reverse that sentence. He knew waiving appeals would lead to execution. He expressed a preference for execution over prolonged incarceration. He said he did not want to spend decades in administrative segregation. He described prison conditions as intolerable. He saw no point in fighting. Sharma found evidence of depression, but not psychosis. Depression alone did not render Simmons incompetent. The Arkansas Supreme Court accepted Sharma's findings. Simmons was competent to waive. Opponents argued the state was facilitating suicide. They noted that Simmons killed his family and then sought state assistance in ending his own life. Legal scholars debated whether execution under those circumstances served justice or merely fulfilled the offender's wish. The court acknowledged the concern but found no legal barrier. Arkansas law permitted waiver. Simmons met the competency standard. The execution proceeded. Advocates for abolition cited Simmons as an example of the death penalty's troubling intersection with mental illness. Supporters noted he was competent by legal standards. Both positions remained defensible. The Simmons case influenced later decisions. Courts considering waiver petitions cite the Arkansas framework. They evaluate whether the defendant has been evaluated by a qualified psychiatrist, whether depression or other mental illness impairs judgment, and whether the defendant's decision is consistent over time. Simmons never wavered. From his initial request through the execution, he maintained his position. That consistency supported the finding of competence. Had he fluctuated, shown confusion, or expressed ambivalence, the court might have denied the waiver. His clarity, paradoxically, sealed his fate. The ethical debate continues. Should the state honor an offender's choice to die, or should it insist on preserving life even when the offender does not want it? The legal question is narrower. Does the offender understand the choice and its consequences? Simmons did. The court acted accordingly. His execution occurred 2 years and 5 months after the crime. No other case in this group moved that quickly. The waiver collapsed the appellate timeline. Simmons chose speed. The state obliged. Whether that choice honored justice or subverted it remains a question without consensus.